Good morning, everyone. Welcome to this latest Fox Williams travel webinar. And today the topic is international sales. So I'm joined today by Lucy England, a partner in the travel team, and Jessica Howard, who's an associate in the travel team. The plan is today for us to talk for about 45 minutes with a bit of time at the end to deal with questions. There is a Q&A box on your Zoom browser. So if you want to drop it in any questions as we go along, please feel free to do so and we'll pick them up at the end. We are then going to try to finish after an hour to let everyone go back to work. A couple of housekeeping matters before I start. This webinar is being recorded. Nobody can see the attendees except for the speakers, and a copy of the recording and the slides will be circulated to those in attendance during the course of next week. So that's it by way of introductory comments from me. If we can have the next slide, please, Dan. So, as I mentioned, this webinar is on the topic of international sales. It's actually something we do a lot of in our day-to-day practice, whether that's helping UK companies sell into other markets, the EU or the US, quite popular markets, but also going the other way as well. So US clients coming to Europe, needing regulatory advice in the UK, EEA, and also beyond into other markets, some of which we'll touch upon today. So the plan is that we're going to focus first on selling into the EEA, and that will be Lucy and me covering that topic. Jess will then cover the travel regulatory implications of selling into the UK. We're then going to look at some other countries in the rest of the world just to illustrate what the regulatory position looks like in other markets before we then conclude with some key takeaways. Next slide, please. And again. So yeah, what we're really focusing on today is selling cross-border. And by that we mean a travel company based in one country selling into another country. And so for instance, UK companies selling into Germany or selling into Ireland. And the basic question which applies in that situation is, do the local laws and regulations apply in that situation, or is it only the law of your home country that applies to those sales? Well, more often than not, the local law, so the law of the local markets will apply, and it can apply in a number of different ways. Obviously, firstly, if your customer terms and conditions with that customer in another market specifies that the law of that local market will apply to the relationship between the travel company, and the consumer in the local market, then obviously that will then bring in the local law and the local regulations both to that contract, and potentially more broadly than that, if you've specified that local law will apply to the entire relationship. So that is one way in which local law can come in. The other scenario in which local laws can apply is if obviously you have some sort of physical presence in the local jurisdiction. So that could be because you have some people, some salespeople, an office, even some servers, some measure of economic activity taking place in the local markets, and that can, depending on the particular country, that can also be a trigger for the application of local travel law and regulation. And the other one, which is probably the most common one, is where you are actively targeting consumers in a particular market. And the state of the law, generally, certainly in the UK and the EU, is that if you are actively targeting customers in another market, then the mandatory consumer protection law of that market will apply. So that will be a way of bringing in the local travel law and regulation to that transaction. And by sort of actively targeting, I mean, there's no sort of comprehensive definition of what that means, but it generally involves looking at a number of factors which would tend to suggest that you are actually trying to acquire customers in that local market. And that could be because you've optimized your sales and marketing activities on that local market, whether that's through optimizing your Google search or your Google advertising to that particular market. And similarly, having local language websites or websites with a local domain is usually a good indicator that somebody's actively targeting a local market. And similarly, displaying fares in local currency and offering holidays departing from the local market can again be taken as indications that you're actually targeting customers in the local market. And in those situations, I mean, particularly in the UK and EU, as I said, those would tend to bring in the mandatory consumer protection laws of the place where the customer is based. So that's it by way of introductory comment. We're then going to move on. If we can move to the next slides, please, Dan, to looking at the EEA, and Lucy's going to start off on this.
Thanks, Reese. Good morning, everyone. Hope everyone is well. If you can move on to the next slide, please, Dan. So yes, start looking at the EEA, and we talk about the EEA rather than the EU because the Package Travel Directive is broader than just the EU. It's the 27 member states plus the Iceland, Liechtenstein, and Norway. So the rules of the EU are a bit broader, but obviously don't apply to the UK anymore since we left the European Union. And there is, to a large extent, a lot of harmonisation across the EEA, as you would expect. That's obviously the point of it. But I think don't be disillusioned by thinking it is all harmonised in every country, because despite that being the initial intention, that isn't quite the case. There is a level of harmonisation with the Package Travel Directive, and as Reece says, we're not going to get into the detail of the PTD today. We assume there's a level of familiarity in the audience of what the purpose of it, at least. And there are a lot of provisions of that apply in every country in the EEA, those being the difference between organisers and retailers, the obligation to provide information on organisers and retailers in different capacities, the rights of travellers. That's the main point of the Package Travel Directive. It's a consumer protection regulation. There's a business exemption if you fit the right criteria, if you're selling B2B. And of course, there's the requirement to have insolvency protection. Now, all of these points apply across the EEA. That is the standard required by the PTD, or the requirements of the PTD. And so there is a level of harmonisation. But I think one of the reasons for this webinar is to sort of help you understand that it isn't just one size fits all, certainly not across the world, and certainly not in the EEA. So unfortunately for those looking to sell internationally. But the trickiest part of the PTD to get right is probably insolvency protection. If you can move to the next slide, please, Dan. This is, as many of you know, there is the concept under the Package Travel Directive of this thing called mutual recognition of insolvency protection, which means if you have insolvency protection under the laws of one EEA state, one EEA country, that insolvency protection should apply for the rest of the EU. Now, on the slide, I've got three different scenarios. So the first one on the left, you've got a travel company in one EEA country, say France or Germany, selling to consumers based in their country. So French customers for the French travel company, or German customers for the German travel company. Fairly straightforward. The company will comply with the French or German rules and regulations, have their insolvency protection in place, and be able to sell in country. That's the most straightforward way. That assumes you have an establishment in an EEA country. If you're not, however, an EEA travel business, or you don't have what's called an establishment in the EEA, you're then sort of a non-EEA country, a third country selling into the EEA, and the UK now being one of those. And there are two different approaches that you could take. The first one in the middle is that you comply with each EEA country's rules and requirements to sell into that country. So, for example, so France, Germany, Italy. To sell into France, you comply with the French rules. To sell into Germany, you comply with the German rules, and so on. But because you, the travel company, don't have your insolvency protection in the EU, you're not established in the EU, you cannot use the principle of mutual recognition to sell across the EEA. And so you must comply with the rules of each country. Now, that, for some travel businesses looking to expand, is the way that they might start. You just test the water in one particular country, sell from the UK into that country, and just comply with the rules of that country. And by rules, I'm talking about the insolvency protection requirements, and Rhys will come on to sort of other requirements, such as licensing. If you do it in more than one country, there's quite an administrative burden to it, and it can be expensive. In insolvency protection in one country is not necessarily the same as another. Some countries, for example, accept insurance. Some accept some require you to join their local scheme. Others are much more flexible and give you different options. So you have to investigate each market to understand which one works for you, or which ones you're targeting, and then understand the costs, obviously, and the administration behind it. And then the third and final scenario on this slide is what we call the EU hub model. And this is where a non-EU EEA travel business creates an EU hub. That's an establishment in an EEA country, and there are requirements of what an establishment is. In some jurisdictions, it is having boots on the ground. It's needing people in country actively working for that business. Other jurisdictions are a bit more flexible on what they see as an establishment, and you have to consider each local regulators' requirements depending on which market you're looking to target. But once you have that establishment in a jurisdiction, and you comply with the excuse me, rules and have insolvency protection in place in that country, that effectively gives you the passport to sell into all other EEA countries under the mutual recognition principle. And so that is what obviously a lot of businesses do. If you're established in the EEA already, it's easier to do that. But if you're non-EEA, that's the first one of the things to think about, whether you want to and whether you can set up an establishment in the EEA. There are, however, so that's the sort of harmonization to a level, that insolvency protection mutual recognition requirement. But some jurisdictions, some EE states, have extended what the PTD requires. And so, for example, in France, it's not just packages that require to be covered by insolvency protection. France, as they were allowed to do under the EU PTD, extended protection to single element travel services. So hotel only sales require insolvency protection, for example. It's not just packages. And so if you were to enter the market through France, you would have to comply with those French requirements to then sell elsewhere. Rhys will come on to, if you were, for example, set up in Germany, wanting to sell into France, and the extent to which you have to comply with the French rules beyond what you already do in Germany. There's a little bit of lack of clarity around that. But there are, I suppose the point is, there are some countries that have gone further than some other countries on the PTD. So the one example is individual travel services. The other one is the obligations of retailers and organisers. Sort of as we know it in the UK, organisers effectively have the most obligations. They're the ones that have to take out the insolvency protection, and retailers can rely on the organisers' insolvency protection. But in some countries, both retailers and organisers are required to get insolvency protection. We have on occasion questioned whether that is correct, because it seems there is then double protection for the consumer. But that is the rule. They are the rules in some countries. So something to be very aware of, depending on which country you want to start selling into. So I'll hand back to Rhys, who's going to talk about the sort of other requirements that might be in place.
Thanks, Lucy. Next slides, please, Dan. So yeah, so Lucy was talking about the implementation of the Package Travel Directive throughout Europe, and that's the main law which applies to the sale of package holidays and linked travel arrangements, of course. But actually, the PTD doesn't say anything about of travel licensing regimes or registrations and things like that. It just talks about rights for the consumer, obligations on organisers or maybe retailers to arrange insolvency protection. What you find is, in addition to that, some markets in the EEA and in the UK have a travel licensing regime, which means that it's a regime which sits alongside the obligations in the Package Travel Directive. It's actually an obligation which requires the travel agent or the travel professional or the tour operator to obtain some sort of license from a regulator before they can trade. So, as some examples on the slide here, Ireland, Irish-based tour operators and travel agents selling holidays to, actually even flights or other transports to consumers, which go from Ireland to a place outside of Ireland. So a package holiday to Spain, for instance, including a flight, requires a license from the Irish Aviation Authority before you can do that. There is an exception for tour operators because there is an option to avoid the licensing regime if you arrange FFI, but not for the travel agents. So there is a licensing regime in Ireland. Similarly, in Austria, there's a licensing regime. If you want to set up a travel company in Austria, there is a requirement to apply to the local authority for a license. And similarly, in Spain and Italy as well, you find similar licensing, or albeit perhaps more in the form of notifications, requirements which have to be made to the local authority, depending on where you're based, because in Italy and Spain it's sort of regional, so each region has its own rules. So depending on where you're based, you might have to provide some form of notification to the local regulator. Now, the interesting thing about these licensing regimes is, as I said earlier, they require often permission to be obtained from the regulator before you can actually start selling in that market. And the requirement to satisfy the licensing criteria, usually published by the regulator. Now, that licensing criteria can be quite broad. There can be a sort of a financial fitness test, as we have with ATOL. That also applies in some other markets. So in order to get a license, you have to show that you are, solvent and able to fulfill the customer bookings that you're taking. There can also be a requirement to have civil liability insurance. And interestingly enough, in some markets, there's also a requirement to have certain sort of professional qualifications. So a requirement that the individuals running the travel company the managers, the officers have certain travel qualifications and travel experience. So that again, I mean, Austria would be an example of that, but that's one of the examples of the sorts of things that can be required in order to get a license. Now, a lot of this can be avoided if you choose sorry, a lot of this can be avoided within the EEA. So if you create an EEA hub, as Lucy explained earlier, in a country which doesn't require a license, then all you have to do is comply with the PTD requirements to arrange insolvency protection, and then you can use that to sell into other markets. However, there are some exceptions to this, and some EEA countries require some regulators require companies selling from other EEA states to register with them, even though they are relying upon the insolvency protection of another state. So, for instance, if you were to be selling from a German establishment into France or Ireland, complying with the German insolvency protection rules, there is still a requirement in France to register the fact that you're targeting customers in that market. So you have to register with the regulator, provide them with details of your German insolvency protection. And it's the same in Ireland as well, as an example of where this requirement applies. Now there is that is a sort of a working practice of these regulators. I mean, it may be questionable in terms of the legality of that. And I say that because the way that the EU single market is meant to work is that you are meant to be able to set up a hub in Germany and you set up a German website and use that and point that towards consumers throughout the EU without having to go through any additional sort of licensing or registration process in other member states. So the whole point is that you're meant to be able to trade cross-border, and the obligation to regulator sits on the home member state. There is actually a case working its way through the European courts at the moment, which looks on that very principle involving Expedia. I think it involves Airbnb and a few other, Amazon, Google, I think, who are challenging certain local registration requirements that they're being made to go through. So that sits on the travel licensing regimes. Next slide, please, Dan. Before we move off EEA and look at what the situation is in the UK, I just thought it was worth mentioning the impact of Brexit on sales into the EEA. And obviously this will primarily apply to companies doing business in both markets. Obviously, things used to be harmonised between the UK and the EEA, but because of Brexit, we now do have some divergence in the rules. We've already talked about how actually you can no longer use your UK insolvency protection to sell into the EEA, but there's also a whole bunch of other requirements that are now requirements in the EEA but not in the UK. So post-Brexit, we've had the Omnibus Directive in the EEA, which deals with things like online search results and, ranking of search results, paid advertising, that sort of thing. So there are EEA-specific rules around that sort of thing now, and also similar rules dealing with customer reviews and endorsements, which apply to in the EEA. So if you are doing business, perhaps cross-border from the UK into the EEA, something to be aware of. And looking forward a little bit, we are going to have divergence between the package travel rules in the UK and the EEA as well, because we have EEA reform, which is working its way through the legislative machinery at the moment. We have a proposal for a new package travel directive, which includes a different definition of a package, as an example, enhanced refund rights for consumers, enhanced rights for organisers to get refunds from suppliers. So all of this stuff is happening in the EEA, not happening in the UK. Similar reforms to passenger rights regulations. So that's primarily, Regulation 261 would be an example of that. There are also going to be new rules on multimodal transport in the EEA. So things are happening there which are going to be different to what the situation is in the UK. A couple of other things just to mention before we move off this slide. I mean, we've obviously had the Digital Services Act come into force last month, fully into force last month in the EEA. Something that we've been tracking quite closely because it impacts our online marketplace clients. So if you're running a platform targeting EEA customers, that's something that you're going to need to be aware of because it's going to require you to implement certain measures aimed at tackling illegal content. And the final one I just wanted to mention was the EU short-term rentals regulation. So again, anyone running a platform making available short-term rentals is now going to have obligations to collect and share certain information about those rentals with the national authorities in the EU. So that's it from me on that, and then I'll hand over to Jess to look at the UK.
Thanks, Rhys. So as Rhys said at the start, I will be talking about what travel companies need to consider when they're based outside the UK and they want to sell to consumers within the UK. And Rhys already touched upon this, but anyone selling packages into the UK, so actively targeting the market, will have to comply with UK laws. And in this case, the key laws, which we've already mentioned, are the package travel regulations and the ATOL regulations. And that's the case irrespective of where they are based. As Lucy says, we do have a version of the package travel regulations in the UK, which are to an extent harmonised in all EU member states because they're derived from the EU Package Travel Directive. And there are several requirements from the PTRs which companies need to comply with, such as information obligations, performance obligations, various travel rights concerning cancellation and amendments. However, I'm going to focus on insolvency protection. Next slide, please, Dan. So for sales to UK customers, what we have in the UK is a distinction between flight-only and flight-inclusive packages on the one hand, and non-flight packages on the other hand. And when we talk about insolvency protection, so as a whole, it must cover refunds to customers, and that can either be the deposit that has been paid or the full price of the holiday. It must also cover repatriation costs if the travellers are already abroad, and any additional accommodation if they have to stay for longer than the holiday was meant to be before they come home. So, as I mentioned, in the for flight-only packages for flight-only or flight-inclusive packages, we have the ATOL regime, which I'm going to come on to talk about in a bit more detail. And for non-flight packages, the PTRs say that there are three options: bonding with an approved body. The second option for insolvency protection is financial failure insurance of the organiser. And then the third option is a trust account with repatriation insurance, if that's relevant. I did mention at this point, although we're mainly talking about packages, the way to protect linked travel arrangements is the same as for non-flight packages. So it'll be those three options at the bottom of the slide. Next slide, please, Dan. So starting with flight-only and flight-inclusive packages, as I mentioned, we have the ATOL regime. And ATOL, as I'm sure many of you will be aware, stands for the Air Travel Organisers Licence, and the applicable legislation is the ATOL Regulations 2012. But the regulations have been updated several times since then, most recently in 2020. Now, any company, irrespective of where they're based, that sells flights into the UK market, whether on their own or as part of a package, must obtain a licence from the Civil Aviation Authority, or the CAA. And this scheme was introduced to provide protection for customers in the event that their travel company ceased trading before or during their holiday. So ATOL holders must provide a form of security to the CAA, which it can call upon in the event of the failure of the ATOL holder. And There's also a flat charge of £2.50 called the ATOL protection charge contribution, which is payable by ATOL holders for each person who books a flight inclusive package or flight only, and that's paid to the Air Travel Trust Fund, which protects consumers in the event of the ATOL holder failing. And just the final point to note on this slide is that ATOL applies both B2B and B2C. So I think there's maybe a common misconception that some people think it only applies to consumer facing sales, but it will also apply if one business is selling to another business. Next slide, please, Dan. So that was just a quick overview of the basics of ATOL, but when do you actually need an ATOL? So in the ATOL regs, there are 3 types of regulated activity, and anyone carrying out these activities will be required to have an ATOL unless they fall within one of the exemptions. So firstly is making available flights. Now, the wording in the regulations is actually making available flight accommodation, but it effectively means anyone that's involved in the flight supply chain. So a practical way of thinking about it could be anyone who passes a flight down from the airline to the customer. So it could apply to aircraft operators, although I should flag that there is an exemption for that. And then coming down the supply chain could also apply to organisers of package holidays, which include a flight, to flight-only sellers, and also travel agents appointed by both airlines and organisers. But once again, there are some exemptions for certain types of agents. The second type of regulated activity is anyone that procures flights as an agent for the consumer. And this is the common model is where online travel agents purchase flights from low-cost carriers on behalf of their customers. And the third type of regulated activity is anyone who facilitates others to make available flight accommodation. So, for example, if Company A facilitates Company B to make available flights, and once again, that could be flight only or a flight inclusive package, then Company A will fall within the ATOL regulations. But the key point to note here is that it will only fall within the regulations provided that it receives the customer payment and passes all or part of that to Company B. So this third type of regulated activity is likely to catch platforms and marketplaces, but as I said, that is only if the facilitating company handles the customer's payment. So as you can see, it's extremely broad, and pretty much anyone involved in transacting flights in any way is probably caught, but there are several exemptions. And if an exemption applies, then an ATOL is not needed. So there are 2 types of exemptions. General exemptions apply to any organisation or sales that fall within the terms of that exemption, and specific exemptions, this is where organisations can apply, and those exemptions will only apply to a named company. I should also mention that it's possible for some sales of an organisation to be exempt from an ATOL, but other sales to not be exempt. So it's important to look at particular categories of sale to see what's caught and what isn't. And we've done a separate webinar on ATOL, so I'm not going to mention really any more detail about the exemptions, but I will just say that, and Lucy already mentioned it, that there is a business travel exemption. So travel companies can take advantage if they make sales to corporate clients for business travel. However, in that case, there must be a framework agreement in place between the company selling the travel services and the relevant business. And if it turns out that you do need an ATOL and you can't take advantage of any of the exemptions, then it can take months to obtain one. So travel companies are advised to apply early, and the application process typically involves applying through an online portal, satisfying certain financial criteria, and passing requirements relating to fitness and competence, which Reese mentioned. Next slide, please, Dan. So in terms of non-flight packages, there are 3 options. Firstly, to register with an approved body, and this must be approved by the Department for Business and Trade. And in the UK, we currently have 2 approved bodies. So ABTA, the Association of British Travel Agents, and ABTOT, which is the Association of Bonded Travel Organisers Trust. And the approved bodies oversee the bonding process to ensure that the bond is at an adequate level to meet the insolvency requirements. And basically, a travel bond is a recognised security guarantee and is calculated as a percentage of annual projected turnover relating to the packages which need to be financially protected. The second way to protect non-flight packages is financial failure insurance of the organizer. And here, the obligation is to make sure that the traveller is named on the insurance policy so they can benefit from the insurance if it's called upon. And then thirdly, we have trust accounts. So if a travel organizer wishes to use a trust account, that account must be held by an independent trustee, and they won't be able to release funds until the contract has been fulfilled. Now, if the contract also includes a carriage of customers, then additional insurance must be in place to cover repatriation and additional accommodation costs for the customer prior to repatriation. They should also flag that the costs of financial protection, irrespective of the method, must be borne by the travel organizer, and it isn't a one-size-fits-all approach. So whichever option you choose to protect non-flight packages could depend on a number of things, such as the size of your business or your business plan. And then the final thing I just want to mention, and Reece touched upon this, is that there are lots of reforms coming down the pipeline. We also did a webinar on kind of what to look out for in the travel industry in 2024 that you can access on our website. But I will just flag, and specifically to do with insolvency protection, that the government is interested in using a greater mix and match possibilities, as it recognises that sometimes it is difficult for travel companies to source insolvency protection. So it's trying to possibly add more flexibility to the mechanisms for non-flight packages. So one proposal is allowing a combination of a trust account and a bond to be provided, in addition to the current option of a bond plus insurance. However, in this case, the whole of the customer's booking needs to be protected. It's also considering a variable APC, and so at the moment there's a flat rate of £2.50, which I mentioned, but the variable APC may depend on the size of the ATOL holder, the average value of the trips, or the financial strength of the ATOL holder. So these are just some of the proposals that are coming down the pipeline, but we will continue to keep you updated of any changes. And that's me. I'll hand over now to Reece and Lucy again.
Yes. So I think it's me first. Yeah, just looking at certain countries in the rest of the world. So if you flip to the next slide, please, Dan. So we up until now, we've obviously been talking about package travel directive, travel licenses in the EEA and UK. There are also similar-ish regimes in other countries, and you find that actually most countries have some form of travel regime that you need to be aware of, although some will only apply if you've actually got a presence in the relevant markets. But certainly the ones I'm going to talk about, they will apply even if you're selling from outside into that particular market. So USA, I mean, I think the thing to say about the USA is that the law isn't harmonized across all US states. So you haven't got an equivalent of the package travel directive. The law is very much kind of varies state by state. And there are seller of travel laws which apply. I mean, it used to be in 5, but now it's in 4 different states. So California, Florida, Hawaii, and Washington. And there is basically a registration requirement, unless it's possible to rely on a particular exemption from having to register. So that means having to fill out the form, provide information, and apply for permission from the relevant state authority for a seller of travel license. And there are typically financial security requirements which go with that. So a requirement to have some sort of bond or trust account to protect the customer money. So annoyingly, registering with one seller of travel authority won't cover you for all authorities. It's very much, as I said at the beginning, a state by state approach. Canada, it's similar to the USA, so there is no harmonized law across all of the provinces in Canada. So there's no sort of PTD equivalent. What you do have is travel licensing requirements in 3 provinces, so Quebec, Ontario, and British Columbia, where there is again a requirement to apply to the relevant provincial authority for a license. You have to fill out an application form, provide information, the information about directors, criminal checks that run against those directors. There's also a requirement in these states to have financial security. So again, some form of trust account or a bond. And also in some of the provinces, there are professional qualification requirements as well as a condition to getting one of these licenses. So pretty tricky if you're looking to sell fully compliant with all of the laws and regulations relating to travel in the USA and Canada. But there we have it on that. So I'm going to hand over to Lucy to look at the other ones.
Yeah, thanks, Reese. Yeah, we've just chosen, Turkey's half in Asia, but these are ones we've looked at recently, which is why we've chosen them as examples. And we've looked at Turkey a couple of times for different clients. But Turkey is a very strict regime for if you want to start selling travel services to Turkish customers. They don't distinguish between packages and sort of single element like we do. It's more around tourist services, but they have a different regime depending on whether you're selling your own services, if you're a hotel chain, for example, or if you're selling something that somebody else is offering, either as an agent or a tour operator. So that's the distinction they draw. And if you are caught, then you have to get a license, and you have to be designated by the Turkish ministry to be a travel agent. They have similar-ish insolvency protection requirements. It's an insurance requirement if you want to start selling into country once you've got your license, or it's a condition of the license. And it's a tricky market. There's a lot of litigation in Turkey by the local, it's called TURSAB, the Turkish Association of Travel Agents, making sure that there is fair competition in the market. So there are some quite high profile cases ongoing at the moment in Turkey. So sort of beware if you're thinking of Turkey as a market. And India doesn't have travel laws, travel regulation per se. It's sort of just about doing business in India, and their test is whether you systematically offer a product or a service to Indian customers, and there's a test for that, and if you do satisfy that test, you're required to have a physical presence. So the question, as Reese says, we often get is, I operate a platform from a country, can I start selling into that country without having a physical presence? And India is a tricky market, so tricky that you can't actually have an app that is downloadable by Indian customers in India without having a physical presence in India. So it is quite restrictive. And they have they don't have tourism laws, but they have these voluntary OTA guidelines that were introduced a few years ago as a way of assuring customers that there is a certain standard being offered by the travel agent and a certain level of service, but they are voluntary guidelines, and you have to be established in country to choose to meet them in the first place if you wanted to. And so that's India, and that's sort of Asia. That's all we'll cover in Asia. You can move to the next slide, please, Dan. A quick look at the Middle East and Australia. The Middle East is a growing market, which is why we've talked about it, or why we are talking about it. Like the GCC countries, the 6 GCC countries, there's no harmonization. They're all obviously separate countries with their own regimes, and tourism hasn't really been a big thing. And a bit like India, there haven't been tourism specific laws in many of these jurisdictions to date, but Saudi Arabia have recently brought in tourism laws, and Oman is bringing in laws in April specifically aimed at tourism. And again, nothing like our package travel regime, and I am yet thankfully to come across across anywhere that has anything like the linked travel arrangements. That's very unique to the EU, but it is being aimed at tourism and targeting tourists in those markets. Yeah, I won't go into any more detail, but there are regimes coming up if you're looking at the Middle East as a market. And finally, Australia. Australia used to be regulated up to about, I think it was 2014, they got rid of their travel regulations. And so it is, again, a question of whether you are doing business in Australia, whether you're carrying on business there. And even if you don't have boots on the ground, don't have an office, you may be classed as doing business in Australia if, for example, you conclude contracts in Australia. And there's questions over how that might happen, but there are definitely things to be aware of in Australia if you're looking at the Australian market. Even though there is no travel specific regime, there are corporate registration and consumer competition laws to be aware of. And that is the final one. I'll just hand back to Rhys to finish off.
Thanks, Lucy. So yeah, key takeaways. Can we have the next slide, please, Dan? So yeah, in essence, as you've seen, there are travel regulations across the world. It's not just something that we have in the UK. There are regulations in the EEA, US, Canada, rest of the world. There are some exemptions, which may mean you don't have to register, but generally speaking, if you are targeting a particular market, then you should expect to be caught by the laws, the consumer protection laws in that particular market. And very often there is a travel regime, or if not, as Lucy mentions, there may be other sort of more broad business registration requirements that you need to think about. There is a measure of harmonization in the EEA. It's not perfect, as we've seen with some of the local registration requirements, which persist despite having a hub somewhere else in Europe. But unfortunately, in places like the US and Canada, there is no harmonization. So if you're looking to enter those markets, you are going to have to look at the particular states or provinces to be compliant. With these travel regulatory requirements, there is often an insolvency protection requirement, and that is often by way of some sort of bond, or it could be something like a trust account, which applies beyond the UK. It's not just a creature of the UK PTRs. And similarly, in some countries, there are licensing requirements. And what I mean by that is before you can before you can start selling in that particular market, you are meant to seek and obtain approval from a particular regulator before you make sales. So that's it on the presentation. We do have a couple of questions, which I will just bring up now. I'll share out equally and fairly between the three of us. So I don't hog all of these. So, Lucy, let me come to you on this first one. So I think the situation is here is that you have a cruise company with an EU hub. So let's assume Germany. They have their HQ in Germany, and they are looking to sell into other EEA countries through a GSA model, which I understand to be an agency model. So I suppose the question is, what's the regulatory situation in that scenario for? And I'm guessing this is for the cruise company.
Yeah, that's a good one. I'd like to be able to say that because they had their German establishment, so supplier has satisfied the requirements in Germany, that they don't have to do anything else. However they sell across the EU, whether it be through a GSA or as the other part of the question, through other trade partners or B2C directly. But that isn't true of every country, unfortunately, and it would depend on which countries you're targeting. So, for example, Spain, assuming the cruise line is the organizer, and they have insolvency protection in place. I mean, this isn't the obligation on the cruise line, but the GSA, as the retailer, also has to have insolvency protection in place. So there's an extra thing to think about there. There might be, if they went into Italy, they may have to notify, depending on which part of Italy they want to feed into. So I think the short answer is they can't just do nothing else. They need to look at who they're selling to and where, and just make sure there aren't any extra boxes to tick. Hopefully that answers that one.
So I think maybe a couple of quick fire ones for me. What's the timescale on the new PTD? I mean, that's anyone's guess, because there is now a process. The draft text has been published. They are consulting on that. It will then go through the legislative machinery of the EU before being formally adopted, and then usually there's a period of time. I think last time it was 18 months for the member states to bring it into force, to put it on their statute books, and then usually then another 6 months to until it actually applies. So I mean, my guess would be something around 3 years. I don't think it's going to be much quicker than that, if I'm honest. And so I think that's it on that. So there's a question here: is it true that in some EU countries it's mandatory to have in place the local office or establishment? Although I think if the travel company did that, it could benefit from mutual recognition. Is this a breach of EU laws? I think in my experience, there is often, if you want to join, so if you're selling, say you're selling from the UK into a local market and you want to join the scheme in that local market, there is often a requirement that the relevant regulator will only allow you to join the scheme if you've got either a local company or a local branch. And I think that's okay from an EU law perspective, because we are outside the EU. So all of these freedom of establishment, freedom of services concepts of the EU don't apply in that situation. And I think the question does go on to say, could you then use that as your kind of EU hub? Well, yes, you could. I think obviously the issue is you have to satisfy the definition of an establishment in the package travel directive. So in order to take advantage of the EU hub principle, you have to be properly established in that country. And there's a commercial and economic test to that, which is potentially broader than just having some kind of registration there. Although the approach of member states differs on that question. So some member states the regulators will expect you to have an office with some people in it, and actually selling, doing the business of selling packages, whereas other member states are much more relaxed about the requirements in that regard. So that's sort of it as a matter of practice on that. And I mean, there's a question here. I mean, maybe I'll come to you, Jess, for this. I think the question is about that some large operators don't take advantage of the mutual recognition regime and register in each country. So I guess the question is, could they? It's not entirely clear. So I think the question is, well, could they choose not to register in each EU country and just create a hub somewhere?
So I think that usually depends on, maybe the number of jurisdictions that they want to operate into. It would be quite an administrative burden and be expensive to kind of, comply with the insolvency requirements in each EU jurisdiction. Whereas obviously creating a hub, you could rely on the principle of mutual recognition. But it may also be that sometimes travel companies feel like, maybe for reputational reasons, if some insolvency protection schemes are kind of more well known, then consumers might have a bit more confidence in that. So that might be a reason why they register in each country instead of relying on, say, one specific scheme if they have set up an EU hub. Don't know if you have anything further to add.
That's good, Jess. I do have one other question to ask because I don't know what the answer to this is. Well, what is the impact of paragraph 2 of the explanatory note to the PTRs on international sales? Now, I like to think that I know intimately all of the regulations in this area, but paragraph 2 of the explanatory note escapes me. So, Jess, if you know, I will owe you a favor for this.
Sadly, I don't know by heart paragraph 2 of the explanatory notes of the PTRs. Shocking. But we can get back to that person, unless Lucy knows it.
No, that one's not top of my tongue either.
Pointing. So I think probably a question for me: do the local laws in the US and Canada apply if you're acting as an agent for a provider of single travel services? So maybe if you're not selling packages, you're selling accommodation only as an agent. Yes is broadly the answer there. It will vary province by province and state by state, but it doesn't just the laws there don't they don't apply depending on whether you're selling packages or not. They will apply if you're selling travel on behalf, which is actually provided by somebody else, so acting as a travel agent. So I think yes is the short answer to that. There's one interesting question here about the role of platforms, and I think the question is sort of specifically directed at somebody like Google. So I think the scenario is you may have an organizer based outside of the UK and let's say EU for this purpose, selling packages to consumers in the UK. So they should be complying with the PTRs and ATOL, but they don't. And I think they're using Google to optimize they're sort of using Google to basically optimize their sales in the UK. And what can be done about Google in this scenario? I think it's actually an interesting one because this is probably where the DSA, so the Digital Services Act, comes into place, where intermediaries or providers of online platforms and online search engines do potentially have obligations to remove illegal content upon notification, and that illegal content can be broader than just sort of criminal activities. It could be something like selling packages and flights into the UK in breach of the PTRs and in breach of the ATOL regulations. So that would apply in the EU under the Digital Services Act. We obviously have coming in the UK something similar, the Online Safety Act, which aims to do much the same as the DSA in that it will apply to online marketplaces and platforms and search engines and put obligations on them to do something if they're facilitating somebody else to kind of disseminate illegal content. So I think the answer is perhaps it's worth looking at those acts if you have a concern about what Google are doing. So I think I'm going to draw a line under things there because it is 10 o'clock and we do try to guillotine these webinars on the hour. So it's just to say thanks to everybody for joining. If there are any questions we haven't addressed, we will follow up on email in the next couple of days. And just to remind you that we will be circulating a copy of this recording and also the slides And if there's anything else that anyone wants to discuss with us, then please feel free to get in touch. Thanks very much.
Thank you.
Thanks, everyone.